This presentation covers civil rights compliance basics for the College of Human Ecology, the College of Agriculture and Life Sciences, Cornell University Agricultural Experiment Station, the New York State Agricultural Experiment Station, and Cornell Cooperative Extension. Please note the equal opportunity statements. As recipients of federal funds, we are required to include one of these statements for any presentation or materials developed for public audiences. Recipients of any federal funding are required to follow civil rights laws and obligations. The minimum expectation is a knowledge of civil rights law, follow a policy of non-discrimination, notify the public of our obligations and their rights, offer equal program opportunity, and offer equal employment opportunity. The primary law of concern makes clear the connection between obligations and federal funding. Title VI of the Civil Rights Act of 1964 provides that no person in the United States shall, on the grounds of race, color, religion, sex, or national origin, be excluded from participation in, be denied the benefits of, or be otherwise subjected to discrimination under any program or activity receiving federal financial assistance. A second law of concern for us is the Age Discrimination Act of 1967. There can be no discrimination on the basis of age in any program receiving federal financial assistance. This applies to employment, programs, and activities. Title IX Education Amendments of 1972 ensures no discrimination on the basis of sex. Access to employment and program opportunities, our promotion and marketing efforts, and our language and pictures depicting programs and activities should demonstrate we don't discriminate on the basis of sex. The Rehabilitation Act of 1973 requires that there be no discrimination on the basis of disability. This applies in employment, programs, and access to electronic and information technology. One reason why I'm reading the slides for this presentation is to facilitate access for individuals who are visually impaired. Americans with Disability Act of 1990, as amended 2008, requires no discrimination on the basis of disability, but also goes beyond that and requires that we work to minimize or eliminate barriers. For example, with new construction or redesign, buildings may need to be made handicapped accessible. For individuals with physical, visual, or hearing impairment, we might offer programs or activities in more accessible locations, present programs or research results using multiple presentation methods, or create auditory recordings of information. Executive Order 13166 protects individuals with limited English proficiency and requires that we work to improve access to services. We have a responsibility to make reasonable steps to provide meaningful access to programs and activities, and the expectation is highest in regions or areas that have a large population of such individuals, where there's frequent contact, and where there's a potential for risk to health or safety. USDA Regulation 7 CFR 15. Any recipient of federal financial assistance, regardless of the amount, is subject to civil rights reviews. Further, the primary recipient of federal financial assistance is responsible for civil rights administration, where the primary recipient has extended the financial assistance to another recipient. In addition to knowledge of civil rights law, all of us, including faculty, staff, graduate students, volunteers, collaborators, and program participants, should be aware of and follow a policy of non-discrimination based on the law. For us, a policy of non-discrimination includes federal and New York State law, plus Cornell University policies. No person shall be denied admission to any educational program or activity, or be denied employment on the basis of any legally prohibited discrimination involving, but not limited to, such factors as race, color, religion, political beliefs, national or ethnic origin, gender, sexual orientation, age, marital or family status, veteran status, or disability. In addition to a written policy, we are expected to actively inform the public that we are an equal program and employment opportunity provider and offer reasonable accommodations for those needing them. Program advertisements, presentations, and printed materials should indicate this and include contact information to request accommodations. In employment, research, and programs, employees or research or program participants should be informed of our complaint procedures. In employment, the procedure is determined by college or unit, and employees should be informed of their contact person or process. For complaints or concerns related to extension programs, please contact Sarah Dayton. For complaints or concerns related to research programs, the contact is Mark Schrader. Individuals may also contact the USDA with their concerns. The Justice for All poster should be hung in any area commonly accessed by the public, such as reception areas, meeting rooms, or classrooms in any building we own or rent. As a recipient of federal funding, we are required to comply with equal program opportunity laws and obligations. EPO laws compel us to intentionally support accessible and inclusive approaches for community engagement and program participation, and the USDA provides specific guidance on how this is to be accomplished. Additional information is available in a separate presentation, Civil Rights and Equal Program Opportunity. We have covered the civil rights laws which are relevant to both equal program opportunity and equal employment opportunity, and reviewed our policies on non-discrimination and public notification. This was a basic introduction. For additional information, please contact Sarah Dayton for Extension Program concerns, Mark Schrader for Cornell University Agricultural Experiment Station concerns, Mark Smith for New York State Agricultural Experiment Station concerns, or your HR contact for employment concerns.